The Osha 3030 celebrates its 100th episode today, and we are joined today by Commissioner Amanda Laihow, Commissioner at the Occupational Safety and Health Review Commission. And today, for the next 30 minutes or so, we will spend time talking with Commissioner Laihow, learning from her experiences as commissioner, and gaining insight from her perspective as commissioner at the Occupational Safety and Health Review Commission on this, the November 17th, 2021 episode of the Osha 3030. Welcome everyone to the Osha 3030 with Manesh Rath. I'm joined today by Commissioner Amanda Laihow. I am Manesh Rath. I'm a partner at the law firm Keller and Heckman here in Washington, D.C., and I am an attorney who engages in the practice of occupational safety and health law. And as I said before, we're honored to be joined today by Commissioner Laihow, who is a commissioner at the Occupational Safety and Health Review Commission. Commissioner, welcome, and thank you for joining us at the Osha 3030.
Thank you very much. And I am so honored to be here at your 100th episode. I remember back in my previous experiences having participated in this, I think when you launched it. So I really appreciate the invite and happy to be here.
Well, we're grateful as well. And Commissioner, I guess the first question I should ask you, as you say, we've known each other for a number of years, worked together in the good cause. And so now that you are a commissioner at the Occupational Safety and Health Review Commission, is it okay if I address you as Commissioner Laihow?
Sure. Thank you for asking.
Absolutely. Thank you. So Commissioner, let's get started. I think first we have a large community of in-house counsel, safety and health professionals, and others who are, including folks at enforcement agencies and the media, who join in as part of our Osha 3030 community, both in the live webinar as well as on podcast and YouTube. And so they come from different levels of experience or familiarity. And I suppose the first thing I'd like to do for that reason is just make sure everyone understands the Occupational Safety and Health Review Commission. Many of them do, but it's also sometimes misunderstood. For one thing, it's not a part of the Department of Labor, and it is not a part of the Occupational Safety and Health Administration.
That is absolutely correct. And I can tell you, we, in my counsel role previous to this and now with this, we've been trying to do a lot of educating of the community. There are very oftentimes people ask me my policy goals at OSHA, and I said, you'll have to go to OSHA to ask that because we're independent.
That's right. The Act, the Occupational Safety and Health Act of 1970, it called for the establishment of three different agencies. Under the Department of Health and Human Services, it called for a research institution, NIOSH, and it called for the creation of OSHA, the Occupational Safety and Health Administration, as a agency of the Department of Labor. And that is an agency that makes regulations and enforces them. And then there is a completely independent agency, the Occupational Safety and Health Review Commission, run by three commissioners, of which you are one. And it is a tribunal where employers and OSHA can take their contested matters to an administrative law judge, and it works all the way up to the very highest level, which is the review commission itself, the panel of three commissioners. Did that say it about right?
Yes, that's absolutely right. There's if I guess you look at it sort of your chart here, the rate below us is the trial level. So you look at it as a court, if you will, where you have an administrative law judge who conducts the trial level and all of the hearing motions, et cetera. And then once that is decided by the administrative law judge, then the case, if either party chooses, would come to the full tribunal, the three commissioners.
And it's an appellate level of review, as you say.
Yes.
And it looks like, looking at this chart here, that there's about a dozen administrative law judge positions.
Yes, that's correct.
Are they all filled right now?
I believe they are at this time. The latest person was hired probably about a year and some change ago over in Denver, in the Denver region.
And that's one of the big challenges for the Review Commission, is to constantly make sure that there's enough law judges, administrative law judges, to keep the case flow
Correct.
going.
Correct. And I think, as with any agency, I'm sure that our chief judge, Judge Rooney, would appreciate as many resources as she could get her hands on. But with the government the way it is, it's, you could always use more, but she does have a full complement right now.
That's great. Judge Rooney, who's been an administrative law judge with the Review Commission for many, many years and is an institution in occupational safety and health law.
Yes.
So you said that the administrative law judges serve as basically the trial level, and they receive the parties. The parties present evidence. They go through pretrial, like discovery and exchange of discovery, and then they have a hearing and they present evidence, and then the administrative law judge renders an opinion.
Yes, that is correct. Mm-hmm.
And then a party may appeal to the Review Commission to hear it as a full commission.
Yes. There is a time period, just like with any appeal that you might have in a state court or federal court, where they have 30 days from that decision of the administrative law judge, either the employer, if they're dissatisfied with the decision, or the Secretary of Labor, who is the other party on our cases, to appeal to the commission, full commission, to hear the case on review. And
what are the other ways that a case can come to the Review Commission as a appellate level of review?
So in my tenure, I haven't seen this happen, but the commissioners could see a case coming up from the administrative law judges, because we are informed when they do have a decision, and we're able to review that decision as soon as it comes out. And if we see a case and the time clock is ticking down and we haven't seen an appeal come to us yet, we could basically take that case, go to the party or parties and say, we want to take the case on review. And I would have to go back and see when the last time that was, but I think, obviously it would be of a novel, issue, maybe looking at a new standard that might have come out, where neither party is sure, whether they should appeal or not. But as I said, in my tenure, I have not seen that yet.
But theoretically, any one commissioner who's made that determination could cause a case to come up to the commission for review.
Correct. Yes. And actually, when one party does petition us, it only takes the one commissioner to decide that they want to take it.
Right.
So
three commissioners don't have to vote on it, and a majority.
Correct. That's what. It's the only time that we only need one of us to basically take something up. Everything else, in terms of motions that might come before us, interlocutory appeals that come before us, or the case decision itself, we do have to have a quorum of 2.
And then there's one more opportunity for the parties to appeal a matter, and it's really almost the last chance, and that's to appeal a case to the federal Article 3 court, which is in this particular case, it's called for in the statute that it would go to a U.S. Court of Appeals at the circuit court level, and that would either be in the circuit in which the case arose or in the District of Columbia circuit, the DC circuit.
Yes, that is correct. And again, once we issue a decision, and this is an interesting point that we've actually been discussing since we issued new rules of procedure a couple of years ago, is once we issue our decision, we basically hand that case, if it does get appealed to the circuit or DC circuit, we hand that case over, and then our jurisdiction is no longer at the commission, which attorneys listening to this would understand, but our jurisdiction would actually cease to exist, because then the case is really with the circuit now.
And they could send it back down for additional evidence to be taken, in which case jurisdiction is reclaimed, I suppose.
Yes, if they issue a decision and ask the commission to do something or review something, yes, it would come back to us. And we've had a few of those come up over the last few years.
So, Commissioner, let's talk a little bit inside Washington. I'm curious. So share with my audience, I remember the day it happened, but share with my audience how, when you became a commissioner at the Occupational Safety and Health Review Commission.
So I was confirmed in January of 2020, but prior to that, previous year in 2019, we had a vacancy on the commission. Our former chair, McDougall, left her seat. And because of that vacancy, I was notified that someone had put my name forward to the White House to be considered as the new commissioner and serving out Chairman McDougall's term. That is the process, and you basically, your name gets put forward, or you put your name forward, and then you go through an interview process at the White House, a background check by the FBI, and then your name gets submitted to Capitol Hill because I'm in a Senate confirmed position. So I go before the Senate Committee of Jurisdiction, which is the Health, Education, Labor Policy and Pensions Committee. And then after that, whatever that timetable looks like, you go through an interview process, a vote in committee, and then you go to the Senate floor for a vote. So it can take several months. So I think from the time my name was submitted to the time, it was March or late March of 2019, and then I was confirmed in January of 2020. So
that is a long time.
It is. And sometimes there are hiccups in terms of where you are in the process of your FBI check and whether that is taking longer, or whether the Senate is jammed up with a whole host of things, including, impeachment trials over the last few years, or whether they just have a lot of legislation on their docket.
I need to have things planned tomorrow, next week, and the next 4 months, 6 months, 10 years. So I applaud you for having gone through that process from March of 2019 through January of 2020, I think you said, yeah. With that level of uncertainty hanging over your head. I think that's impressive that people can withstand that as you did. So to be clear, and I just met Commissioner McDougall exactly a week ago. You're essentially fulfilling the vacancy left by Commissioner McDougall.
That's correct.
And then when you joined in January, the commission was composed of, I believe, you as well as Commissioner Atwood, and Commissioner Sullivan was still there.
Yes, that's true. It was it was three of us because Commissioner Atwood, I'll back up a bit. Commissioner Atwood's term actually had expired in April of 2019. So at that point in time, Chair Sullivan was the lone commissioner from the time of the beginning of May of 2019 until January of 2020, until Commissioner Atwood and myself were confirmed by the Senate.
And I want to get to that in a second, because there are moments in the 50-year history of the Review Commission where there have only been two commissioners of the three possible positions and one commissioner. And you just described one instance where Commissioner Sullivan was there by himself. But in January, when you are confirmed and sworn in, there are now three commissioners. How long did that last?
That lasted for about a year and a half. So
that's a great year and a half for the commission.
Yes, it was. I think the important thing to understand is the three of us, and soon to be hopefully Commissioner Harthill, who's now going through the confirmation process, we all have staggered terms. So we don't all serve for the 6 years all at the same time. So because I'm fulfilling former Chair McDougall's seat, I had 4 years. And so my commission will end in April of 2023. Chair Atwood will, hers will end in 2025. And then Commissioner Harthill will, once she is confirmed, would end in 2027. So that there's never, the way that it works is that, yes, there might be one commissioner at certain periods of time, but that the commission wouldn't be fully vacant at the same time, unless we all three decided to leave at the same time for whatever reason.
Well, thank you for explaining that process and that history of the past 2 years, because I think that the constantly changing composition is elemental to, we talked about determining whether a case can get sent up for review and just one commissioner can make that decision. But then to actually decide a case, you need a majority of the three potential positions, commissioner positions.
Yes, that's true. So right now we have two of us. So we will take up a case, and the hope is during our deliberation, and we do have a deliberation meeting on the case, that the hope is that the two of us would agree on the outcome, and that we could go forward with a 2-0 decision, which I think our website, you can look at all of our decisions that we've issued, but we are very proud of the fact that we have been able to issue some decisions with just the two of us currently.
I've made that comment to others in the Osha law community before, that the fact that there's only 2 commissioners and they've been nominated by opposing political parties, and that Commissioner Laihow and Commissioner Atwood have been able to render decisions on what I think are important areas of Osha law, is a testament, I think, to what remarkable people both commissioners are, that they can find the areas of common ground to continue to conduct the business of the Review Commission. I can't imagine that that's always easy, but when you and Commissioner Atwood have done it, it has always been impressive to me.
Thank you very much. As I said, we're both very proud of that, and we are looking forward to having Susan Harthill join us. I do think there are going to be, again, our docket is public, so I think there will be some very difficult cases that the 3 of us will be taking up, and so to have that third voice on the commission will be very important. As holding a position as counsel to Commissioner Sullivan prior to this, it's very important. The 3 councils of the commissioners work together, and there's a lot of negotiating that goes on back and forth to see if one commissioner is almost quite on board, but not quite, if there's some way to get them on board. I liken the counsel position to a clerk in a circuit court or a Supreme Court, that they're working behind the scenes to find any case law or any other legal issue that you could get the 3 to agree on, ultimately deciding the outcome of a case for 3-0. Now, that doesn't always happen, of course, and you can probably see that in the cases when we had 3 of us, or then previously when Chairman McDougall was there, there was disagreement on the case law and how to apply it. But I think that that's also healthy for the commission and healthy for the audiences who this affects, that you have sometimes a 3-0 opinion, but you also sometimes have a 2-1 where you can see where the application of the law falls out.
So how difficult has it been to look at cases where perhaps you get the sense that the commissioners, having only 2 right now, have not been able to agree, and what happens to the case at that point? So
we, again, I'll pat ourselves on the back a little bit. We haven't had that come up with Chair Atwood and myself. What I can say is that if there is an impasse, obviously the administrative law judge's decision would hold as the law at the time, or maybe there's a way to table the case at that point in time, or just not take it up at all, knowing that it's such a very novel issue, or it's a very difficult issue, and not sure where we would fall down on that case. Obviously, we don't know how we're going to decide until we get into the deliberation meeting. So it's a fine line that the chair, who sets the agenda of what cases to take when, it's the fine line of not really reading the tea leaves, but kind of understanding, where we may decide on a case. But at the end of the day, if we take up a case and we are at an impasse, then we're at an impasse. And we may issue a decision of a 1-1. And again, it would then fall to the administrative law judge.
But it's still subject to the possibility of appeal to a U.S. Circuit Court?
Correct. Yes, it is.
So that's an interesting possibility. I don't recollect such a case. Maybe there are some that I'm not aware of or I don't recollect, but a decision that's 1-1 dissent, I wonder what the precedential value of such a decision would be.
Yeah, I'm not sure. We haven't seen it since I've been there, and I don't recall even before my tenure of folks talking about that. I don't think the commission in general likes to do that because
Right.
it doesn't really set up good case law for your clients or for the Department of Labor. So you really want some clarity on these standards and when they're actually citable offenses and when they're not. So I think it's not good for the OSH law community to have a 1-1. And, you know, a case could actually automatically go to the circuit anyway. So if there were the two of us and someone wants to just go to the circuit, I suppose they could, or they could wait out the 30-day time period here. Or they just kind of wait out the time period for us to get a third commissioner. So it all just, you know, it's kind of shooting the dice a little bit on that. But again, we haven't had an impasse as evidenced by the cases that we've issued decisions on.
Right. And they've been, I think, extremely instructive decisions. So I'm thankful that they've been issued. Commissioner, I'm curious, your experience prior to serving as commissioner was as counsel to the chair of the commission. But before that, you worked on labor and employment policy on behalf of U.S. manufacturers.
Mm-hmm.
And I'm curious, now that you're a commissioner, how your experience working with manufacturers on labor and employment and occupational safety and health policy has shaped your ability to serve as a commissioner.
That's a great question, and one that actually was asked of me on the Hill when I was going through the confirmation process. Obviously, because I'm supposed to be very neutral, which I consider that I am, the policy side of things is a much different lens to look at, because we were at the time with the manufacturers helping to shape the regulations that OSHA might put into place, or how a regulation might need additional guidance from OSHA because of a particular workplace or a particular environment or a particular workforce. Working at the commission, you're working really within the four corners of that standard, and not being subject to the policy issues that I might have been working or advocating for before in my time there. But it's looking at the application of that standard to this particular incident or the particular workplace environment at the time. Obviously, there's a lot of cases we have where an injury occurs, a citation comes, and sometimes you have to step outside of that, the injury and what happened with the injury, and was there an offense or a violative condition that, irrespective of the injury, it was still there and present. So you kind of have to take yourself out of however egregious the injury might be, or the incident might be. You're just looking at the standard, whereas before, as a manufacturing lobbyist, I was looking at the whole policy, the economic impact, is this manufacturing plant going to shut down because of the feasibility, all of the costs that this is going to, that the manufacturer is going to incur from implementing this standard. So I think it's very different to look through those two lenses. I do think one very positive intersection is that I'm able to understand a workplace and how it runs better, because I was able to tour some manufacturing plants and talk to people on the ground, and look at things and how they actually worked and how things were coming together in the manufacturing plant. So when I get a case in and they're describing what type of business this is, I can kind of see this in my head about what this business is producing and what the workplace might look like.
This is, I think, has to have been a difficult transition to make, because you've done the policy side for so many years, but I can understand now a lot better the different lenses that you have to look through to evaluate a case when it comes to you. So thank you for explaining that.
You're welcome.
Next question. If you could change anything about the review commission procedures, what would you change and why?
Well, I think we've had to change procedures over the last almost 2 years. And I think it's while we weren't sure where we were going to land in terms of how efficient and effective we would be during a agency shutdown, almost in terms of physical office space. I think going to a virtual Zoom, whatever platform world in terms of being able to conduct business has really helped in terms of getting things moving off of our docket. Because without having these platforms and conducting meetings virtually, we wouldn't have had when Commissioner Sullivan was there, we had 34 cases we decided, and we did, I would say 95% of those via Zoom or another platform virtually. So we were able to still conduct business. And I think that's getting the government into that space. Even though it was forced, I think it's a very good thing that government can still run and we can still hear cases and we can still effectuate, the decisions in this world that we're living in now.
I came over to the Review Commission to just sit in the pews to hear a hearing. I think it was heat stress,
Yes.
general duty clause citation. Commissioner Sullivan was the chair at the time. And I don't think I realized at the time that I was listening to one of the last in-person hearings that we would have experienced for a while.
Right. I know. Yeah, I don't think any of us did. And I will say, to follow up on your question, I do enjoy the oral argument piece of the job. And unfortunately, we haven't been able to do that. And so I'm hopeful that once we turn into 2022, that we might be able to take up a case for oral argument, because I think it's good for the parties. It's good for us to ask these questions live as opposed to, asking our counsels about them. But it's also good for the public to be able to come in and see who we are and what we're doing and what things we're thinking about. Because if you go to any court or hear any Supreme Court argument, the questions, you're sort of understanding, where the mindset of a particular judge might be. So the questions we may ask, you might understand better where the mindset, where we're coming from might be.
I thought, Commissioner, that one of the things you might say about anything you'd like to see changed might deal with the 3-commissioner format. I know the Mine Safety Review Commission has 5 commissioners, I think, and some attorneys have done a comparison of the number of times where there was an insufficient quorum to render a decision over the 50-year history of these 2 agencies. I've only analyzed the Occupational Safety and Health Review Commission statistics, and I came to the conclusion that about 1 out of every 4 years there is an insufficient there's vacancies on the commission, so that there's an insufficient quorum to render decision, unless, of course, extraordinary commissioners like you and Commissioner I would have been able to arrive at a consensus. But 1 in 4 years out of 50 years means that there's been at least, and this is an approximation because I didn't look date to date, I just looked at years, but at least 11 years of insufficient quorum in the history of the Occupational Safety and Health Review Commission. I believe that it came up in Congress as a proposed, because it would require a statutory amendment, and I think it came up in maybe 2004 or 1994. It was a while ago. But it doesn't have any currency at the moment. No,
I think it's something that I know that Chair Sullivan was very interested in learning more about the history of why we only have 3 as opposed to the 5 at the Mine Safety Commission. And, NLRB has 5, EEOC has 5. So we're sort of in our own on our own island over here with 3. And I'm not quite sure, why that decision was made. But I think that there definitely would be interest in seeing that change, just simply from the statistics that you pointed to. But also, I think in looking at research from this, I think EEOC might be one of the only agencies where you can actually have a holdover, which is another issue. And a holdover is, so if when Commissioner Atwood's term expired in April of 2020 and April of 2019, a holdover would have allowed her to stay if she was going to get renominated to stay there until she's reconfirmed. We don't, and that's very explicit for the EEOC. We don't have that at the commission either. So I think either having 2 more commissioners or allowing that holdover provision for a few months would at least allow the commission to continue to issue case decisions and not have that gap, as you would say, with just 1 commissioner, because as we know, the most recent was with Chair Sullivan, and he had about 9 months by himself. And believe me, it's frustrating because the only thing he could do is take a case on review, but then the case sits on the docket. So
yeah, Commissioner Sullivan complained that he had nothing to do or not enough to do.
Right.
And that's unfortunate because Commissioner Sullivan is extremely dedicated to the cause
Yes.
of promoting occupational safety and health. So I threw you my statistic, Commissioner, however imperfect that statistic might be. Do you have any statistics from the review commission that you'd like to share with us?
Sure.
My inner statistician loves these things. So any inside statistics you'd like to share would be
Yes, sure. So what we're very proud of the fact is that since Chair Atwood and I have been confirmed in January of 2020, and now through Chair Sullivan term ending, we've actually decided at the commission level 38 cases. So, and before Chair Sullivan left, that was 34 cases. So with 3 of us, we were able to get through 34 cases in a pandemic world, in a virtual world. And now
that's about 3 a month.
Yes. So
That's
we were very busy. So even working from home, we were doing a lot of work. And then since Chair Sullivan has left, we've decided 4 cases, and that's since April of this year. So we're navigating, when those meetings will be back in person with each other. Right now, I can tell you that we are still doing meetings virtually. Even if we are in the office, we have extensive protocol for safety of our coworkers, and I can say that we've been successful at it. So we'll continue until we decide that we don't need to do that anymore in terms of a virtual world. In the 2020 case statistics, getting onto your other statistics for you, we had 34 PDRs, petitions for discretionary review, and of those 34, we directed 22 to come to the commission. So that's a pretty significant amount. And then at the administrative law judges caseload in 2020, they had 3,093 cases, and 1,762 were without a hearing, which if under our procedures, we have that simplified proceedings, or there could have been a settlement prior to trial. So the commission's very busy, and we are taking a lot of cases. We've updated our procedures; those are online as well. We're doing electronic filing now at the trial level, which is a good. We decided to do that before pandemic, so thank goodness we've updated our systems, and parties know that they can file everything electronically. And they are also at the trial level, at the ALJ level, they are conducting trials virtually as well.
That was a welcome development, the electronic filing. I was one of the first to be asked by the secretary, I think has a lot of the role of a clerk of a court, to participate in electronic filing to make sure it worked. And I'm glad that's up and running full steam. It's a great development for the parties.
Yes.
So I'm going to ask you my last question, Commissioner, and this is a question I should warn you I ask of anytime I'm in a conversation with a judge at the appellate review level, trial level, anytime I run into a young person who has finished serving as a law clerk. I'll even call her a bailiff if I can. But the question is, you've seen a lot from the perspective of the bench of practices by litigators. And as a litigator, I'm dying to know, what are the practices you've seen that you think attorneys could have done something better in order to better advocate for their clients, whether it was on the agency side or the employer side?
That's a great question. And I think it's an important one. I know that Chair Atwood talks about this as well in her talks and our panel discussions that we've had over the years. But I think a very important thing that we've run into a few times is photographs that are in black and white, and somehow they get into the record black and white, and or they're very grainy. And so when I guess submitting a photo into evidence, make sure that it's very crystal clear and the point, because sometimes that's what we're looking at, in terms of whether we can actually see it. As a litigator, you're living and breathing this case all the time, so you understand, the small details. But us looking at it with fresh eyes, if we have a photograph and we can't necessarily see in looking at the transcript what you're referring to or what DOL is referring to, it makes it difficult for us to look at that very small, minute detail that might hinge one way or the other on how we decide the case. I think also what we've run into is there are some times where we get a case and we'll look at the transcript and say, oh, they should have asked, or why didn't they ask this follow-up question? And again, it's either with the private bar or the Department of Labor. And so when developing your questions at trial, I would just maybe try to think of this as you might have to come before the commission on either side and say, what would the next follow-up question be that a commissioner might be looking for? Obviously you all are very busy, and so the time spent on these cases I know is a lot, but there are a few times where we have looked at transcripts and we kind of will see some holes in the transcript, or perhaps there should have been a witness called and maybe we don't know that that witness was unavailable or doesn't work for the company anymore. But we've run into that sometimes, as well as experts. I know they're costly, but there are some instances where we feel as though the expert, either it's a report that's submitted into an evidence or just even testimony, could have helped either side come the other, go to the other direction from where we were deciding. I think that's important. I know that it's very important when you get into some technical cases, so I think having an expert at the ready or even having a report from an expert is very important. Again, I know Department of Labor with resources, sometimes that's an issue, but sometimes it can make the decision easier for us in terms of where we see it falling. So those are little practice tips that I would recommend.
Those are great tips, and I'm enriched instantly by hearing those tips from you, and the perspective that you bring to this is authoritative. I think with expert witnesses, the other place where they come in handy is when you look at commonly accepted practices or good engineering practices or generally accepted principles of safety and health, that those who have experience in the industry can shed light on that rather than just leaving the parties to dispute the question of what's a good engineering practice or generally accepted practice. This is all extremely helpful. That was my last.
Oh, sorry. I guess I would just add one more thing. Sorry about that. We've talked, when it comes to us, you're submitting briefs. And so I think one of the other things that Commissioner Atwood and I have talked about is being respectful of the other side, and in the briefs or even the PDRs, depending on, not to be too inflammatory of the opposing party, the opposing counsel, the opposing client, if you will, that it's very important for us to just kind of state your legal rationale as to why this case should be taken, and not get into sort of the other issues in terms of whatever happened at trial and personalities or the like, because we don't, it's not nice for us to read those things. And we've had those come up on occasion, and it's a distraction.
That's another great tip. And I think that I hear judges constantly reminding practitioners at the bar to improve their efforts towards civility. Yes. And to stick to the fact and law and let those speak for themselves. And I don't think that reminder can be issued often enough in my day-to-day experience. I think that reminder from anybody from the bench, and in particular from a commissioner, is a welcome reminder for all. And so thank you for that last point.
You're welcome.
That'll be the last point for today's OSHA 3030. This, I should point out for everyone, we are pre-recording this on November 15th, and we're going to broadcast this on November 17th in order to accommodate Commissioner Laihow's schedule. So thank you very much for joining us, Commissioner Laihow, despite your busy schedule. The OSHA 3030 will come back on December 15th, 2021. That'll be our 101st episode. And as many of you know, we rebroadcast all of our programs on YouTube as well as a podcast. So please subscribe on podcasts through your favorite podcast app and check it out on YouTube. This interview with Commissioner Laihow, which is, I think, an invaluable service to the occupational safety and health law community, will be posted likewise on YouTube on our website at khlaw.com, as well as a podcast. So thank you for contributing this invaluable knowledge, Commissioner. We have sister programs for those organizations that have to comply with other statutes, TSCA or REACH. Our TSCA 3030 and REACH 3030 will be broadcast on December 8th. And those times are posted here, 1 p.m. and 1:35 Eastern. So please check those out as well if your organizations are responsible for those compliance with those statutes. That's it for us for this episode. Commissioner, I want to thank you again.
Thank you so much. It was my pleasure.
And thank you all for participating in this month's OSHA 3030. Until we see you next month, stay safe.